The two officers planted themselves in front of Courtroom 14B at 8:47 on a Tuesday morning, and when the woman in the green dress tried to walk through the door, one of them put his hand flat against the frame and said, "Ma'am, this proceeding is closed to the public." She told him she was not the public. He told her she needed to step back. She reached into the leather satchel on her shoulder, the kind with a brass clasp that had been worn smooth by 23 years of handling, and began to remove her identification. The second officer put his hand on her arm, not roughly, the way a man does when he is certain he is right. The woman stopped. She looked down at the hand on her arm. She looked at the officer's face. Then she looked at the courtroom door with the small brass plate beside it that read, "The Honorable Constance B. Adeyemi Bright." And she said, quietly enough that only the two of them heard it, "I suggest you read the name on that plate." The officer who had touched her arm had not read the name on that plate. He had read the green dress. He had read the worn leather satchel. He had read what he thought he saw. And what he thought he saw was not a federal judge. What happened inside Courtroom 14B 22 minutes later was not something Officer Darren Polk or Officer TJ Meadows had prepared for. But the woman in the green dress had been preparing for rooms like that one for 41 years. Her name was Constance Beatrice Adeyemi Bright, and she had turned 58 years old 11 days before that morning. She was 5'4", 134 pounds, and she had been carrying those pounds on 6-hour nights of sleep for the better part of a decade, because that was what the work required. She wore the green dress, a jersey wrap from a consignment shop on Morrison Avenue in the 3rd Ward that she had paid $14 for and worn to 3 different occasions since, because she believed that a garment well chosen was worth every repetition. And over it, a gray blazer that had lost one of its lower buttons sometime in the previous month, and which she had not yet replaced. Not because she could not afford a new blazer, but because the day had not yet come when she felt the missing button was the thing that needed her attention. Her hair was natural, and pulled back with a tortoiseshell clip her daughter Amara had given her for her 55th birthday. The clip still had a small piece of the original packaging cardboard wedged beneath the hinge, because that was how Amara had found it in the store, and Constance had never removed it, thinking she might, then deciding she preferred to leave things the way her daughter had given them to her. She smelled faintly of cedar and something like the warm paper smell of old books, which was not a perfume, but simply the accumulated presence of the life she lived. Mornings at a desk surrounded by law volumes dating back to 1973. Evenings in the same chair with the same lamp burning while she read decisions that would inform the one she wrote. There was a woman at her church on Emancipation Avenue who had once told Constance that she had the smell of a library, and Constance had taken it as the finest compliment she had ever received. She had grown up in the 5th Ward of Houston, Texas, in a house on Lockwood Drive that her mother, Eugenia Adeyemi, had cleaned by herself every Saturday morning beginning at 6 a.m., regardless of what the previous week had cost her. The house had 3 rooms and 1 window that faced east, and Eugenia cleaned it the way she cleaned everything, thoroughly, without commentary, as though cleanliness were not a standard to be reached, but a form of testimony. Constance had watched her do it every Saturday for 16 years, and had never once heard her mother call it hard. "The work asks what it asks," Eugenia used to say, wringing the mop into the bucket near the back door. "You answer." Constance had been answering ever since. She had been the first student from Wheatley High School in 11 years to receive a full scholarship to the University of Texas School of Law. She had graduated 3rd in her class in 1991 and had spent the next 8 years in the U.S. Attorney's office in the Southern District of Texas before being appointed to the federal bench by President Clinton in 1999, confirmed by the Senate by a vote of 61 to 38. She had served on the bench of the United States District Court for the Southern District of Texas for 23 years, 11 months, and 14 days as of the morning she stood outside Courtroom 14B with Officer Polk's hand on her arm. She had heard 2,847 cases. She had never once been late to her own courtroom. In her satchel, Along with the case docket and a legal pad, and the pen she had been using since March, a simple black ballpoint her clerk, Marcus, had left on her desk as a replacement after her previous one ran out, and which she had been reluctant to replace because Marcus had written "Good luck today" on the box. In his precise, careful handwriting, she carried a small framed photograph. It was of her mother, Eugenia Adeyemi, standing in front of the house on Lockwood Drive on a Saturday morning in 1978. Eugenia was holding a mop. She was not smiling in the way people smile for cameras. She was smiling in the way a person smiles when they are somewhere they chose to be. Constance placed that photograph in the right-hand corner of her bench every time she presided. She had done it 2,847 times. She was not going to stop doing it today. The case scheduled for 9:15 a.m. in Courtroom 14B was United States v. Polk and Meadows, a federal civil rights proceeding arising from an incident in the Sunnyside neighborhood of Houston 14 months prior, in which officers Darren Polk and T.J. Meadows had been recorded detaining a 67-year-old man named Otis LeGrand for 9 minutes on the steps of his own home while searching his pockets for a weapon he did not have. The recording had 2.4 million views on the internet before the Department of Justice opened its investigation. The case had been assigned to Judge Adeyemi Bright 6 weeks prior. The assignment had been standard, a rotation of the docket through the available judges in the Southern District. There had been no drama around it, no motion to recuse, no procedural challenge. It was simply the next case on the wheel, and she was the next judge. Officer Polk had seen a photograph of the judge exactly once. In a newspaper article he had scrolled past on his phone 3 weeks before the trial date. He had not looked closely. He had looked closely enough to see that she was a black woman, and then he had put his phone away. The federal courthouse on Allen Parkway opened its security doors to the public at 7:45 a.m. Constance arrived, as she always did, at 8:30. She signed in at the marshal's desk, took her key card from the rack, and walked to the elevator. She was wearing a visitor's lanyard that morning because her judicial ID badge was being reissued. She had reported it missing the previous Friday, and the replacement had been submitted to processing and was not ready. She had the temporary paper credential in her satchel and the lanyard around her neck that identified her as a court visitor, pending reissuance of the permanent credential. This detail matters. It is the kind of administrative gap that looks like a loophole only to people looking for one. The corridor of the second floor of that courthouse smelled of floor cleaner and the faint ghost of burnt coffee from the cart at the far end of the hall. Fluorescent light, the kind that gives everything a slightly underwater quality. Constance walked the length of that corridor the same way she had walked it on 241 previous mornings, steadily without performance, with a satchel over her left shoulder and the legal pad tucked under her arm. She had spoken to Marvella Osei at the coffee cart already, had her ceramic mug of black coffee with both hands, had thanked Marvella the way she always thanked Marvella, and was 7 steps from the door to Courtroom 14B when Officer Polk stepped in front of it. The woman who ran the coffee cart on the second floor of the federal courthouse was named Marvella Osei. She was 71 years old and had been working that cart for 9 years. And in 9 years, she had poured coffee for prosecutors, defenders, marshals, court reporters, and 4 different federal judges. She knew Judge Adeyemi Bright by name, by order, 1 coffee, black, no sugar. In a real ceramic mug if possible, in a paper cup if not, and by the particular way the judge said thank you, which was not the way most people said it. Most people said thank you in the direction of their wallet. Judge Adeyemi Bright said it while looking directly at Marvella's face, as though she were the only person in the building worth thanking. Marvella had seen a great many things in 9 years at that cart. She had seen a defense attorney vomit in the hallway before closing arguments. She had seen a prosecutor weep in the stairwell after a verdict. She had never seen Judge Adeyemi Bright arrive at that courthouse, anything other than exactly herself. So when Marvella watched from the cart at the end of the corridor, as Officer Polk placed his hand on the judge's arm at 8:47 a.m. on that Tuesday, She set down the ceramic mug she had been filling and watched the whole thing without blinking. She watched the judge stop. She watched the judge look at the hand on her arm. She watched the exchange of words she could not hear from 40 feet away. And when Marvella saw the judge reach into her satchel and begin to remove documentation that the officer then did not wait for, Marvella pressed both hands flat against the counter and stayed exactly where she was. Because she knew, from 9 years in that corridor, from 9 years of watching who got held up and who walked through and who was asked to explain themselves and who was waved forward without a question, that she was watching something that needed a witness. If this story is already sitting somewhere in your chest, stay with me, because what happens in the next few minutes is the part that changes everything. What the two officers did not know, because they had not looked closely enough at the document the defense team had filed with the clerk's office 4 days prior, was that the proceedings in courtroom 14B that morning were not a preliminary hearing. They were the formal bench trial. Judge Adeyemi Bright was the finder of fact. There was no jury. There was no higher authority in that room than the woman in the green dress. The United States Marshals who served as court security for courtroom 14B had not yet arrived at their posts when Polk and Meadows took up their position at the door. They had been assigned from the defendant's department and had arrived 23 minutes early, which no one had thought to prevent, because no one had thought anyone would have reason to. The defendant's lead attorney was a woman named Patricia Solis. She had been practicing law in Houston for 19 years, and she had been standing in the corridor near the attorney's entrance, reviewing her notes, when she saw what was happening. She watched Officer Polk step in front of Judge Adeyemi Bright. She watched the hand on the arm. She watched what happened next. She set her own notes face down on the bench beside her and stood still for 4 seconds, weighing something. Then she turned and walked in the other direction, toward the elevator, where she took out her phone and called her co-counsel. What she said on that call would become relevant later. What she did not do was walk toward the officers and intervene. She was their attorney. She was already navigating enough. 2 other people were in that corridor during those 7 minutes. A paralegal named Jerome, early 20s, who stopped walking, looked at the scene, and then looked at his phone. A court reporter named Denise, who arrived at 8:49 a.m., took in the situation in one glance and walked to a position 9 feet from the door where she could see and hear what was happening without becoming part of it. Denise had a yellow notepad. She began writing. The head of court security for the Southern District of Texas was a man named Leonard Akabe. He was 54 years old, 6'1", built like someone who had spent 20 years carrying weight, which he had first in the Army, then in federal security. He had been in this building for 18 years, and he had learned 2 things in those 18 years that most people in his position learned the hard way: that a problem ignored in a corridor became a problem recorded in a report, and that the fastest way to make a quiet situation loud was to arrive running. He was at his desk on the 3rd floor when his radio crackled at 8:49 a.m., and a U.S. Marshal named Tanya reported, in a voice that was controlled but only barely, that 2 of the defendant's officers were blocking the courtroom door and that the judge was standing in the corridor. Leonard Akabe put down his coffee. He stood up. He buttoned the top button of his uniform jacket. He walked to the door of his office and then to the elevator, pressed the button, waited, stepped in, took it to the 2nd floor, and covered the distance from the elevator to courtroom 14B in exactly 41 seconds without breaking stride. Officer Polk heard the footsteps before he saw the man. He turned. He saw Leonard Akabe walking toward him in a marshal's uniform, badge forward, with 2 additional marshals 6 steps behind him. He saw Denise, the court reporter, who had not moved from her position 9 feet from the door and whose pen was still in her hand. He looked back at the judge. He looked at the brass plate beside the door. He read the name on the brass plate for the first time. His hand dropped from the doorframe before Leonard Akabe said a word. Leonard stopped 3 feet in front of the 2 officers and said 6 words. "Step away from the door now." Not a question. not a request framed as a question. A sentence with a period at the end of it that had no room inside it for a counter-argument. Meadows stepped back first. Polk followed. Denise moved to the door. Leonard Ashaby held it open. Judge Adeyemi Bright walked through it at 8:54 a.m. She had not raised her voice once. Inside the courtroom, the air conditioning was running low, and the room held the particular stillness of a space that has been formally arranged but not yet inhabited. The overhead lights were on. The clerk's table was set. The two long tables for prosecution and defense were empty. Constance walked to the bench, set her satchel on the chair behind it, opened the brass clasp, and removed her legal pad, her pen, the printed case docket, and the small framed photograph. She placed the photograph in the right-hand corner of the bench. She looked at her mother's face for 2 seconds, the way she always did. Then she sat down, opened the docket, and began to read. The courtroom filled at its own pace. The prosecution team arrived at 9 a.m. The defense team at 9:04. At 9:07, Patricia Solis took her seat at the defense table and did not look at the bench for the first 30 seconds. At 9:10, the door at the back of the courtroom opened, and Otis LeGrand walked in. He was 68 years old, wearing a brown suit jacket over a gray shirt, and he moved the way a man moves when every part of him is composed, but one hand is gripping the back of his chair to hold it. He sat down in the gallery. He put both hands on his knees. He looked at the bench. At 9:02 a.m., Judge Adeyemi Bright had asked her clerk Marcus to transmit a 2-page written communication to 2 offices. The communication went to the Office of the United States Attorney and to the Internal Affairs Division of the Houston Police Department. It was a precise chronological account of the events in the corridor beginning at 8:47 a.m., including the timestamp recorded by the building security system, the names of the 2 officers, and an attached statement from Denise, the court reporter, who had submitted her written notes to the clerk by 9:01. The final paragraph noted that in 23 years on the federal bench, Judge Adeyemi Bright had never been required to document an obstruction of her own access to her own courtroom, and that she was documenting it now not for the purposes of personal grievance, but because the Southern District of Texas maintained records, and what happened in federal corridors was part of the record. The communication was received by the U.S. Attorney's Office at 9:08 a.m. By 11:30 a.m., the chief of the Houston Police Department had been briefed by his deputy. By 3:15 p.m., the HPD Office of Inspector General had opened a formal inquiry into the conduct of Officers Polk and Meadows. By the following Monday, both officers had been placed on administrative reassignment pending the outcome of that inquiry, and the HPD had issued a mandatory retraining protocol for all personnel assigned to federal court buildings. 4 hours of instruction covering federal court authority, judicial decorum, and the legal definition of obstruction of official proceedings. The first session of that training was scheduled to be held at the federal courthouse on Allen Parkway. It was held in a conference room 20 feet from Courtroom 14B. The bench trial itself concluded 11 days after it began. Judge Adeyemi Bright's findings were entered into the record in a 61-page written opinion. The opinion found that Officers Polk and Meadows had violated the constitutional rights of Otis LeGrand under the 4th and 14th Amendments. The language of the opinion was precise, measured, and entirely without theatrical weight. It did not call the officers monsters, did not call the city of Houston negligent, did not editorialize beyond the law. It stated what the evidence showed. It stated what the law required. It stated the remedy. The city of Houston was ordered to pay Otis LeGrand $340,000 in compensatory damages. The department was ordered to implement a series of structural reforms to its stop and frisk protocols within 180 days, subject to independent monitoring by a court-appointed compliance officer, whose reports would be filed with the court quarterly for 5 years. Otis LeGrand was 68 years old by the time the opinion was filed. He had been sitting on those steps in Sunnyside the morning of the original incident because he was waiting for the 7:14 a.m. bus on Cullen Boulevard that would take him to his job at the laundry on Belfort Avenue, where he had worked for 11 years pressing and folding other people's clothes for $13.85 an hour. He had been detained for 9 minutes. He had missed the bus. He had arrived at the laundry 47 minutes late and had been docked half a day's pay, $55.40. He had not called a lawyer that day. He had gone home, taken his shoes off, and sat in the kitchen for a while without turning the lights on. He had called his daughter in Beaumont that night and told her what happened, and she had asked if he was all right, and he had said yes because he did not want her to worry. He had gone back to work the next morning. He had taken the 7:14 bus. He had continued taking it every morning for 14 months while the case worked its way through the federal system. And he had not said much about it to anyone because there was work to do, and the work asked what it asked. When the judgment was announced, Otis Legrand was on his break at the laundry. His daughter called him. He went outside to take the call and stood on the sidewalk in his work apron in the October afternoon heat, one hand holding the phone. The other pressed against the brick wall of the building. He did not cry. He stood there with his hand on the brick for a long time after his daughter stopped talking. Then he said, "All right, baby." Then he went back inside and finished his shift. Marvella Osei heard about the opinion from Denise, the court reporter, who came down to the cart at 4:20 p.m. the day it was filed, and told her the whole story from beginning to end, while Marvella listened without interrupting. When Denise was finished, Marvella poured herself a cup of coffee, something she almost never did before closing the cart, because the coffee sat heavy in her stomach in the afternoons, and drank it standing up, slowly, looking out the window at the end of the corridor at the parking lot below, where the afternoon light was going amber on the asphalt. She did not say anything for a moment. Then she said, "She walked in there and did her job." Denise said yes. Marvella said, "That's the whole thing. Right there." Then she began closing down the cart, stacking the ceramic mugs in their tray the way she had done 900 times before, moving in the unhurried rhythm of someone who understands that the small daily acts of a life are not the background to its meaning. They are the meaning. Constance Adiemi Bright drove herself home that evening in a 2017 Volvo S60 with a cracked dashboard mount for the phone holder and an air freshener shaped like a pine tree that had long since stopped smelling like pine. She drove the 22 minutes from the courthouse to her house in the 3rd Ward, parked in the driveway, and sat in the car with the engine off. Not because she was unsettled, because she had learned over 41 years that the days worth keeping needed a moment to be kept. She sat there, and she did not review the morning's events with any particular heat. She thought about Otis Legrand's hands on his knees in the gallery, and about the way he had looked at the bench when he came in. She thought about the 7:14 bus. She thought about the $55.40. Then she went inside, made herself a bowl of rice and tomato stew with a piece of fried plantain, called her daughter Amara, and told her about the missing button on the blazer, which Amara reminded her she had mentioned 3 weeks ago. Constance said she knew. Amara said, "Mom," Constance laughed, the short, quiet kind, and they talked for 27 minutes about nothing in particular, which is the kind of conversation that costs nothing and holds everything. On the wall of her study at home, alongside her bar certificate and her judicial commission, and a framed copy of the Senate confirmation vote, Constance kept one other thing. It was not a photograph or a plaque. It was a single piece of paper torn from a yellow legal pad, edges gone soft with age, with 11 words written on it in her mother's handwriting, from a letter Eugenia had sent her the week before the confirmation hearing in 1999. The handwriting was large and careful. The letters formed the way a woman forms letters when she wants them to be read long after she is gone. The 11 words said, "The work asks what it asks. You answer." 2 officers stood in front of a door and decided, without a single piece of evidence, that the woman on the other side of their decision did not belong there. They were not, in their own estimation, doing anything unusual. They were reading a surface, a green dress, a worn satchel, a visitor's lanyard, and acting on what they read. the way systems have always read surfaces and acted on them. But a surface is not a person. A surface is the outermost layer of a life that has been building for decades before the moment you encounter it, through every Saturday, cleaning a 3-room house before the sun came up, through every year in a classroom that didn't see you, through every door that opened slowly or not at all until the day you stopped waiting for it to open and walked through it yourself. You have stood in front of that door. Not in a federal courthouse, perhaps, in a meeting room where someone spoke around you. At a counter where they looked at your clothes before your face. In a waiting area where everyone else was helped first, and no one came to ask what you needed. You have stood there carrying everything that qualified you to walk through it, while someone who had not read a word of your record made a judgment based on the hem of your sleeve. The question that door put to Constance Adeyemi Bright is the same question it puts to all of us. Do you perform the smallness they're asking for, or do you state the truth and let the truth do what it does? She stated the truth. Quietly, in 6 words, without raising her voice. And then, she went inside and did her job. The door closed behind her. The photograph went up in the corner of the bench. The work asked what it asked. She answered. If you have ever stood in front of a door that had your name on it, leave your answer in the comments. I genuinely want to read it. Did you back away, or did you say what needed to be said? What did it cost you? What did it give you? Subscribe for more stories about hidden strength, quiet power, and the people this world overlooks until they change everything. I'll see you in the next one.